Be cool, be kind, be classy. The cupcake's so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. We're back. Hello, my friends. Today is still Friday, December 5th of 2025. And today we're going to the Zoom hearing for AIDAN Kearney in the two remaining cases. Well, the 2023 case and the 2025 case. The 2023 case is for many alleged victims of witness intimidation, including the House defendants and others. Surprise! And the 2025 case is the window intimidation case that is still out there from a time when AIDAN Kearney looked in a window at Dini Pizza and said some things to a camera that Chris Albert and Colin Albert thought were very intimidating. And so here we are. Cosgrove has surfaced. He has filed a response to the motion to disqualify him from this case. Finally. And let's take a look at it real quick before we get into the Zoom room, just in case they decide that they're actually going to listen to this today. So we're not going to read the whole entire thing, but I've highlighted the pertinent portions, pertinent portions of it. And I think he just filed it today. And of course, this is way overdue, but what else is new? And boy, let me just tell you something. He comes for Lindsey in this, and I don't know if she's seen it yet, but I will say, hell hath no fury, Bobby Kazi, hell hath no fury, and you may have just unleashed some serious rage because the things he says about Lindsey are not classy. Let's go. Here it is. This is the Commonwealth's memorandum in opposition to Attorney Bederow's, and then he puts in quotes, affidavit in support of motion to disqualify. The defendant, AIDAN Kearney, has filed an affidavit in support of motions from attorney Mark Bederow. As with a previous Bederow affidavit, henceforth, the motions are phantoms. He says. And there's no memorandum of law accompanying the non-existent motions, he says. You don't come for Bederow and you don't come for Lindsey or you might, I don't know, regret it. As there is no memorandum of law accompanying the non-existent motions, the Commonwealth infers that the affidavit in support is intended to serve all three functions, and assuming arguendo that this court consents to accept it as such, the Commonwealth offers the following response. Well, Mr. Cosgrove, considering that you completely failed to respond to the mega motion and then filed a motion to extend your time to answer with your actual response, which was quickly granted, I might add, because it is better to beg for forgiveness than ask for permission. The defendant first asked this court to preclude the Norfolk County DA's office from appointing another special prosecutor to the 2024 case. And he goes on to say that that is moot because we know that the DA's office issued a null pros and decided to just drop that case involving Lindsey Gattani as a witness. And then he says, in a very snarky manner, listen, I appreciate snark, but there's a point in legal pleadings in which that becomes a little bit over the top. And he says, the DA's office has since entered a null pros on that case. So the defendant remains free, of course, to contest the validity of that null pros by litigating whether the Norfolk DA's alleged irreconcilable conflict of interest. I can't read it because there's a stamp over it. And insisting on the revival of that indictment. But so far, he has shown no sign of doing so. Like, oh yeah, you can oppose the dropping of those charges and ask that we give you the charges, bring the charges again, but we don't think you're going to do that. Next, the defendant asked the court to disqualify Special Prosecutor Cosgrove from the 2023 case because of his alleged irreconcilable conflict with Ms. Gattani. Much has been said in the previous filings with respect to Ms. Gattani, and she herself, with prior leave of this court, has filed a number of pro se documents, right? Because they allowed her to. All of that pays examination, but the Commonwealth offers a brief background summary, and here's where they take liberties with their description of Lindsey Gattani. Gattani is a single mother and a faithful, perhaps even compulsive follower of online postings on such outlets as YouTube, X, and Facebook. In this context, she viewed some of the defendant's online postings related to the then pending Karen Read case, sent him a laudatory message, ordered one of his, quote, free Karen Read t-shirts, then sent him a photo of herself wearing that shirt. Correspondence ensued, and not long thereafter, an intimate physical relationship bolstered by Kearney's bragging about his inside knowledge of the Karen Read case, dinners and drinks, use of the internet to exchange texts, including those with explicit sexual content, and the defendant's sometime practice of videoing their sexual escapades with his cell phone camera. Oh, here we go. This is coloring outside the lines. We talked a lot this morning in the Brian Walsh case about the Massachusetts State Police coloring outside the lines for decades. This is wild. That a special prosecutor who was using Lindsey Gattani as a witness in his cases would now go on to completely obliterate and disparage her in his legal filing. But we're here to read it, so let's keep going. At some point, the Gattani-Kearney relationship began to founder, and about the same time, Gattani began to have doubts about the innocence of Karen Read. Whether on her own initiative or as defendant posits, the influence of other denizens of the online community, such as Catherine Peters, Gattani contacted Lieutenant Brian Tully, who was leading the Norfolk DA's office investigation into the intimidation of witnesses in the Read case by the defendant. Tully interviewed Gattani. The Commonwealth had already developed another witness, Natalie Wywicki Berschneider, aka Natalie the German, who could attest to communications between Karen Read and the defendant during the months of April and June 2023. Gattani's information confirmed such contacts after that date based on what the defendant had told her. Here's what they're going to say. They're going to say, we don't really need Lindsey as a witness. We never needed Lindsey as a witness because Natalie. And so therefore there's no conflict. This is the craziest opposition that I've ever read. One of them, I can't pick which one in this case is the most crazy, but let's keep going. Do you think he meant to say flounder? He said founder. I don't know. They really don't proofread anything. But the misogyny is screeching from every paragraph of this. And I am absolutely blown away. How dare he? She was your witness. She was your cooperating witness. She testified in front of the grand jury when you tried to indict Karen Read and AIDAN Kearney, right? It's going to be on Zoom. We're in the Zoom room. It's not starting until 2:15. Keep your panties on. It's mind-blowing. Tully reported on the interview to Special Prosecutor Ken Mello, who had Gattani served with a grand jury subpoena. Gattani had apparently hoped not to have to testify and began to panic upon receipt of the subpoena. She telephoned the defendant and informed him that she had been subpoenaed and attempted to minimize her role in the matter. After some discussion, the two agreed to meet at Gattani's apartment building, where Kearney demanded to examine Gattani's cell phone and took notes on some of its contents. He urged Gattani to delete various items from her phone, representing that he had checked with his attorney, Timothy Bradel, and that as there was no preservation order in effect, all right,
We just ask people to remain on mute, and if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, Mr. Cosgrove.
Go ahead, Tim.
Mr. Bradley, you're muted.
Sorry, Your Honor. Hello, Tim Bradel for Mr. Kearney, Your Honor.
Good afternoon, Mr. Bradley.
And Mark Bederow for Mr. Kearney. Good afternoon, Your Honor.
Good afternoon, Mr. Bederow. Good afternoon, Mr. Kearney. Okay, folks, first time meeting, so let's have a brief before we get into the substance. I've noted from the docket on this case that there were already a couple of judges who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Bederow. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
All right, excellent. I'm glad to hear that. With regard to Mr. Bradel, Mr. Bradel and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more. I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, we handled cases co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants, at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradel. With regard to Mr. Cosgrove, when he was just Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that Judge Cosgrove, then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom. Certainly no social dealings with them. Anyway. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case. So I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s. Moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have a prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we can handle it. At least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerks' offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion or allowed it in some modified form to set up a taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team. And then at that point, the Commonwealth would get the information as approved by the court to go through it. And assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this: as I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download of 2 phones, which is in the Commonwealth's possession and which has been turned over to the defense. And there are other electronic devices which were seized as a result of the search. And that's what is subject to the ongoing taint team here.
And there's no conspiracy charge between Reed and Kearney in this case, correct?
No.
So presumably any evidence we have with regard to Kearney is going to come off his own phone, I take it.
Well, that's the situation now. I can't speak to what might be discovered in the process of the search. The conspiracy that's alleged in the search warrant is conspiracy to intimidate a witness. The charges against Mr. Kearney here include intimidation of a witness. So it could be relevant, although obviously, no, if any conspiracy indictment resulted against Mr. Kearney, it could not be tried with the indictments here absent his consent.
Okay. So, Mr. Bradle, briefly, anything to add to that in terms of just what procedurally would have? I don't want to get into the substance of that issue. We can deal with it if we need to. But procedurally, you sort of think that's the way it would go?
Judge, we are interested in dealing with the disqualification motion first. Attorney Bederow filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by...
I'm going to come to that, Mr. Bradle.
Yeah.
I just want to make sure we understand the impact of Judge Krupp's.
Sure.
Judge, if I may, and I don't want to merge the motions. I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary, or one of the primary sources that led to the warrant to go after Miss Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Kearney, that implicates the disqualification issue. At this time, I'm unaware that Miss Reed has joined that motion, so I don't want to speak for what her counsel would advise. But to the extent Mr. Kearney is involved in anything to do with what we're calling the open investigation involving Miss Reed's cell phones, we think that the disqualification as it relates to Mr. Kearney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did up until the point where
I'll get to that. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come. And what Attorney Cosgrove chooses to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later. And it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification?
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay. Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.
Okay. How does now, Mr. Bederow, you've got some other business that's going to happen up in Essex County. You're scheduled for trial up there?
That's February 9th, Your Honor. That's correct.
How soon before that are you going to?
Your Honor, I could, give me a moment.
Hold on, Attorney Cosgrove. Mr. Bederow, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Bederow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk.
Okay. Oh, I understand. Maybe is it? Should we do maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
It's the 23rd.
Attorney Cosgrove,
I can do the 23rd.
Mr. Bredel.
Yes. Thank you, Your Honor.
All right, so we're going to mark that up for January 23rd. I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drabs without, as far as we can tell, respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks, we're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control. And we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Bederow's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed. Does include materials that I received from Mr. Bederow, notably a grand jury exhibit that they recently complained that they, I'm sorry, received from Mr. Mello, not from Mr. Bederow. Notably a grand jury exhibit that the defense has complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello.
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let me know. We can get to it quickly in the Zoom and deal with it.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits from 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with the Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradle, Ms. Bederow?
It's a little premature for us, Judge. We're sort of baking the cake right now. And we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are
Sure.
all the same folks. And it seems like this case, in terms of evidentiary, the acts themselves, I don't want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
It's a very fair characterization, Your Honor. There's a bit more to do on the newer indictment. We don't have grand jury minutes even yet. And
well, I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Carney?
It's Kearney, Your Honor.
Carney, I apologize.
Okay.
So look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradle?
I think so, Your Honor.
When do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. There's just so many. This taint team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
Just wait, I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, um, I don't associate myself with all of Mr. Bradle's comments. I agree with his bottom line. This is a complicated case in some respects with quite a bit yet to do and a lot of contingencies. And obviously, if your honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial
Well,
as well. I will say,
let me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
it is accurate, Your Honor, but if you disqualify me on the 23 case, it wouldn't make any sense as far as I'm concerned for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th?
I can do
Any
all
of
that.
those?
I can pretty much make those dates work. And I've checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have
Sure.
access to that docket right now. But pencil yourself in for around that time. And we'll
Okay.
pick this up once we get through the motion to disqualify, which will be on the 23rd. Okay? So, but let's try to work our way towards that date, and get this thing in front of a jury and get it resolved one way or the other. Okay? What else can we
Sounds good, Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically.
I would read Judge Doolin's order to be a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. Look, if there's a deadline set.
If that's Your Honor's interpretation, I can certainly comply with that.
Attorney Bradley and Attorney Bederow and I have it.
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that I'm not even sure that, Mr. Bradley, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk Clerk's Office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there, but if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank
Copy.
you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
Thank you, Your Honor.
All right. Anything else we can do today?
Not for the Commonwealth. Thank you very much, Your Honor, for your time.
So let me ask you one more question before we go. Are all the papers that I need for the disqualification motion filed?
No, Your Honor. Just a couple of hours ago, Mr. Cosgrove, I think, filed a response that, frankly, we had anticipated earlier, but we filed something addressing that yesterday, which I don't know if the court has seen or not. And Mr. Cosgrove filed something today. We've perused it. I believe I'm going to want to file just a brief reply in the next 10 days or so.
Brief reply. We have lots of
I'll do my best.
lots of paper already in this.
I may have an additional filing as well, but it'll be well within the 10 days that Mr. Bederow speaks of.
I know that the civil rules have already been brought into play here in the pleadings here, that they don't apply, but there is that motion reply, sir reply, and that's it. You can file what you need to file, but
Yes.
it just doesn't, it's got to end at some point. All right. So file what you need to file. I want everything filed 10 days prior to the hearing. Okay, so no filings will be accepted on the disqualification issue unless there's new evidence after 113. Let's get this thing squared up and ready to be decided that day. Or argued that day, decided shortly thereafter.
Yes.
All right. Anything else we can do?
It's good, Your Honor. Thank you.
All right. I'll as soon as I get to Suffolk and I have a better idea where we're going to sit, I will give you folks notice as to the time and as to the actual time of the hearing and the courtroom in which we'll be. That'll be an in-person hearing.
Thank you, Your Honor.
Thank you.
Mr. Bederow, do you intend to be there in person?
I will. Yes.
Excellent. Because Zoom is a little difficult when some people are hybrids are difficult. Let's put it
Yes.
that way. Okay, that's all we have today. Thank you very much, Margaret. You can close it up.
Thank you.
Thank you, Your Honor.
Thank you.
Margaret, we love Margaret. We love Margaret. Yeah, if you tuned in and you saw me having a little tantrum, it was because somebody who was on the Zoom had me playing in the background. And so the court thought that I was not muted. I also was in the Zoom room. And so everyone heard me talking as if I was the idiot who didn't mute themselves. But I absolutely do mute myself. And like I tell each and every one of you every single time, if you are going into a Zoom room, you absolutely need to mute yourself. Just have your default setting on mute as far as Zoom goes, because now it looks like I did something that I didn't do. It may not have been a troll. It may have been a viewer who actually just had me on in the background, and that's what had happened. It's not funny because it's like the 10th time that it's happened and people think it's me, and it's not me. All right, here's what's happening here. First thing that Judge Belizos did was explain to all of the parties his connections to Canton, his connections to the other attorneys, his connections to, I don't think he said he had any connections to any of the parties or the witnesses, did he? And then he put it all out there and he gave everyone the opportunity to see if they had any objection to him sitting on the case, because he has been specially assigned to sit on this case. It has been taken from Judge Krupp, and now he is the one sitting on this case. Seems okay for now, but he grew up in Canton. Just can't get away from that place, can we? And it is worth pointing out that Brian Walsh is on trial right now for the murder and dismemberment that he's already pled guilty. Not really the murder of his wife, Anna Walsh. Her body has never been found, and his trial happened faster than AIDAN Kearney's trial will happen. Okay, Anna Walsh went missing on New Year's Day, 2023, and Brian Walsh is currently on trial now, less than 3 years later. However, AIDAN Kearney was arrested when? October 2023. And so his trial will be more than 3 years after his arrest. Why? Because they haven't turned over any damn discovery. Why? Because Ken Mello, health issues. Why? Because special prosecutors. because Michael Marcy has a conflict. Why? Excellent questions that you should ask all of the people who are going to run for district attorney to take Michael Marcy's place, including Adam Deitch, who happened to be part of the U.S. Attorney's Office. I think he was the right hand to Josh Levy during the investigation of the murder of John O'Keefe. So let's hope that he wins the election. It should be dismissed, but it's not going to be. The motion to disqualify Cosgrove is not even going to be heard until January 23rd. That is going to be on Zoom because this judge is moving to Suffolk. Wait, is it? No, it's not going to be on Zoom, right? Didn't he say in person? January 23rd. That's the only date that we have so far. That's going to be the motion to disqualify Cosgrove. He doesn't seem to think that he should have to be disqualified because we're going to finish reading his opposition. But he said, but if you do disqualify me on the 2023 case, if I live to see another day, that's what he meant. He didn't mean if I die. He meant if I live to see another day, meaning if you don't disqualify me, then I'll see you then I will come in for the motion to dismiss. However, obviously they can't hear the motion to dismiss until it's decided whether or not he's disqualified, because part of that motion also is not only should Cosgrove be disqualified because Lindsey Gattani's a witness and she sued him, but Michael Marcy's office in its entirety should be disqualified and precluded from appointing any other special prosecutor, because Lindsey Gattani has also served notice on Michael Marcy saying that she intends to also sue his office. But as we know, there are prerequisites to that, including filing a notice of presentment upon the municipality or the state office or city office that you intend to sue. And she has done that. And so for those reasons, Cosgrove and Marcy should be disqualified, in my legal opinion. Therefore, in order to continue to persecute or prosecute Aidan Kearney, they are going to need to find another district attorney's office to want to do that. And the chances of that may be slim. But what they really, 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 really want to do is to destroy Aidan Kearney and to financially ruin him. You're right, Michael. And to do everything that they can to destroy this man's life for asking questions like a journalist. Possibly the only person to ever be prosecuted under the witness intimidation statute. Aidan is here, I think, in the chat, and he says something like that his trial would not happen until after the election in November. Correct. But it would still be while the current DA is sitting, right? Because the trial would happen in November. I mean, the election would happen in November, but the new district attorney would not take office until the beginning of January, right? No, it is not January 13th. The next date is January 23. Yes, they are draining his pockets, and this is outrageous. It is important to note Brian Walsh also pled guilty to the same statute that Aidan is indicted under. The witness intimidation statute also includes a paragraph or a separate charge of lying to the police. It's all in the same statute. The witness intimidation, misleading police. Brian Walsh also was indicted for that and has pled guilty to that because he led the police on a wild goose chase after knowing and had them searching for his wife, whom he knew had already passed. And that's about all that they talked about. Unless you have any other questions, we're going to get back to reading the papers because we need to finish Cosgrove's opposition to the motion to disqualify him. And boy, does he disparage Lindsey Gattani, and she is not going to be happy. It is January 23rd. That's when it's going to happen, 2026, for the motion to dismiss. And it's going to be in Suffolk County because that is where this Judge Bederow is sitting. And I don't know how far away Suffolk is from Norfolk, but you can tell me because you guys know. Thanks, Gigi, for gifting 5. The blue curtain behind Cosgrove was something out of I don't even know what, a horror movie. Chris Bueller says $5 to buy a bigger sheet to hide the hoard. There seemed to be a lot of clutter behind him. I don't know if he is planning on also starting a YouTube show, but if he does, that'll be interesting. He's got the background already. And delay, said Kat Randall. Thank you. And on top, Thank you, says, we have found Chaka's actual father and room. Anthony says, Bederow's Brady shirt should have 14 on it. And Charissa gifted a membership. Thank you. How much it costs Turtleboy every time they move it, says Beth Ellen. I mean, listen, attorneys bill by the hour. Good legal representation is not cheap. It's not cheap. Is this judge in Suffolk right now? Because we know some of the counties do not use Zoom. I think Essex does not use Zoom because we've tried to watch some things on Zoom and they're like, yeah, no, we don't use that. You have to call into a phone line. It's like a party line. So wherever he was today, they have Zoom, but actually we use Norfolk County Zoom to get in. I have so many questions. January 13th is the final date for a reply to be filed. That's what they were talking about. That's why you're confused. But January 23rd is going to actually be the argument date on the motion to disqualify. And until that motion is decided, the motion to dismiss will not be even have a date, because if Cosgrove is disqualified, then they're going to have to find somebody else. Whether or not they're going to be able to find somebody else remains to be seen. And that new attorney will have to come in, get up to speed, respond to the motion to dismiss. See? TV says Cosby needs to answer in adopted Mello's voice. Oh, wouldn't that have been great if he just started all of a sudden, like, had a voice box at this hearing and said, well, if Mello was here, here's what he would say. And then he could change his voice to adopt Mello's voice. Thank you, Ellen, for your 5. Thank you, Honey Bear. Cosgrove's background is ridiculous. Thanks for hanging out for a year. Christy Mel says, did he send a raven like Game of Thrones? It's like carrier pigeon was busy, so snail mail. I don't know. But apparently Krupp has an order that all of the papers have to be filed in paper form. They can't be filed electronically in Norfolk County. So Cosgrove, I guess, lives far away. He doesn't want to make the schlep all the way to the courthouse to deliver the papers. And I guess none of his not so confidential informants will run the errand for him. I'm not quite sure how that works, because now they're backing away from that person as well, Kate Peter. So your guess is as good as mine, Crazy Mel. Thanks for your 10. And Julia, thanks for your 20. Says, God forbid if Cosgrove passes, does this all go away? No. But that's also not what he meant. He meant if I live to see another day, as in if you don't disqualify me. So no, because Ken Mello has been sick, Cosgrove took over for him. Now he got him. And now he was among the missing for a long time. And this is just a big joke. This is a big joke. It's a big joke. Everybody who's watching this worldwide knows it's a big joke. Every attorney who has ever practiced law for one day knows that this is a big joke. And this is not how cases are supposed to be handled. They're not supposed to go on and drag on for years and years and years. This is not a murder case. Okay? Karen Reed's first trial, let's think about this. Karen Reed's first trial began in spring of 2024, right? We were there. We watched it. That was 2 years, a little over 2 years from the date of John O'Keefe's murder, for which she was acquitted. But she wasn't acquitted until the second trial. And so even Karen Reed's trial, which they tried to convict her of murder of a Boston police officer. He was off duty, but he still was a Boston police officer. That was even held within a little over 2 years after the alleged crime that Karen Reed did not commit. Belezos is the name of the judge, Belezos. On top says this guy Kazi's going to be, well, thank you very much for your thoughts on top and for your 5. And Gigi says Cosgrove couldn't put a 50 piece. Okay, I'm not going to thank you for your super chats, but let's try and just keep it a little bit more classy than trying to, denigrate a man who's clearly retired. Listen, like Howie Carr says, he's triple dipping. All right. He was a prosecutor. Then he was a judge in Norfolk County. And now he's got a side gig or a side hustle. He came out of retirement for this case. He's triple dipping. What happened to the 6th Amendment right to a speedy trial? They don't have that in Massachusetts. Thank you, Beth Ellen. Yeah, they don't have that there. Donkey's Noggins into the almighty, beautiful, hot. Thank you very much. Haas long before Cosgrove recuses himself. He should. He absolutely should. And you know what? Now that he's got a chance to think about it and he put the hours in on the reply or the response to the motion to dismiss and the response on the motion to recuse. All of those are billable hours. He'll put in his billable hours for November. And today we're in December, so he'll put in some billable hours for December. And maybe then he'll be like, you know what? I decided I'm just going to recuse myself. Will he do that? I don't know. My crystal ball is broken, but I do have a magic 8-ball. Where's my magic 8-ball? Oh, it's right here. Here's the magic 8-ball. Will Cosgrove recuse himself? Magic 8-ball, tell us. And it says, and I kid you not, better not tell you now, because many of you might throw things at your television. Moxierella says, I would have pulled out a giant, obnoxiously big pencil, Zoom appearance, and made sure they all saw that as I penciled in the November 2026 trial date. Well, actually, now it's actually into December 2026, right? 635. Travis says, if the court insists on allowing judges to use Zoom, at least invest in some better audio and video, in some cases, equipment. Attorneys do the same. Well, listen, every attorney who's been practicing since 2020 has been on Zoom and doing Zoom court appearances ever since. And people should be pretty up to speed. But that is why Cosgrove is not, because he's been in retirement until he came out of retirement, especially for this case. Kyle says in January, let's get a new judge and delay more. I don't think so. Kay Willis is here. She's a realtor south of Boston. If you want to get the hell out and put your house on the market, call her, because she's always here and she's always gifting the memberships like it's Christmas. Thanks, Kay. Cindy said, what judges recused themselves? Judge Frenier. Judge Frenier recused herself from hearing an issue in the Brian Walsh case regarding the Proctor federal materials. She recused herself from hearing that specific issue because she said the attorney that the Commonwealth hired to go into federal court to argue that motion was one of her mentors. And in good faith, as a judge, she could not hear that issue. And she stepped down from hearing that. She is currently trying the Brian Walsh case. And if you're not watching that with us every day, what are you doing? Anna says, Cos delivers discovery by carrier pigeon. Yes, he does. And Bradford says, Suffolk County is Boston. Norfolk is the neighboring county. Very close. Okay, so it's not like anybody has to schlep any further than it seems like Cosgrove has to schlep from wherever he lives to Norfolk County to file the papers. Thank you, Jackie, for thanking me and for hanging out with me for a month, and Kimberly for being here for 7. Well, let's do it, you guys. Let's get back to Cosgrove's opposition to his disqualification that he just filed right before this hearing, right before the hearing. Okay. I think I can take it off slow mode now for a moment. Or at least it'll make it a little less slow. Let's make it a little less slow. All right. Getting back to the disparagement of Lindsey Gattani, because Cosgrove seems to think that's a good thing to do. If you weren't here at the top of the hour or at the top of the stream, which I thought we've been here a little over an hour. So at the top of the stream, we started reading the Commonwealth's memorandum in opposition to Attorney Bederow's affidavit in support of motion to disqualify. And in his first ramblings, Cosgrove argues that this isn't really a motion. This isn't really a motion. But if you're going to consider it a motion, here's my opposition to it. I'm going to read Bederow's reply after I read this response, because I thought this disqualification motion was going to be argued today, because, why wouldn't you think that? Bederow has said he does want to reply to this. So after we read this, Cosgrove's opposition, we're going to read Bederow's reply brief that was filed yesterday in the motion to dismiss. So that is the order of things. We're doing this first because I already started reading it before. And here we go. I'm going to start again from the Commonwealth, offering a brief background summary in complete and total disparagement of Lindsey Gattani. Here we go. Gattani is a single mother and a faithful, perhaps even compulsive follower of online postings on such outlets as YouTube, X, and Facebook. In this context, she viewed some of the defendant's online postings related to the then pending Karen Reed case, sent him a laudatory message, ordered one of his free Karen Reed t-shirts, then sent him a photo of herself wearing that shirt. Correspondence ensued, and not long thereafter, an intimate physical relationship, bolstered by Kearney's bragging about his inside knowledge of the Karen Reed case, dinners and drinks. Well, I think he would dispute dinners, but you can refer to AIDAN to let you know about that. Use of the internet to exchange texts, including those with explicit sexual content. And the defendant's sometime practice of videoing their sexual escapades with his cell phone camera. See what he's doing here? Do you see what he's doing in his is his misogyny showing in his disparagement or his disparaging of Lindsey Gattani, who at one point was the star Commonwealth witness? There was no meal of food, says Laura and Glamasuse and Southern Girl. And now he will stop at nothing to publicly disparage her and make her look like a hooer. Okay, I'm just going to say it. That's what he wants to make her look like publicly. I'm not going to allow it. I'm going to read the papers, but I'm not going to allow it. I think it's disgusting. Blessed Mom says, why is Cosgrove acting like this? Because Massachusetts and misogyny. And so many of you wrote me emails about this. We'll get into that later, but let's finish this for now. At some point, the Gattani-Kearney relationship began to founder. I don't know what that means. Maybe flounder, but it says founder. And at about the same time, Gattani began to have doubts about the innocence of Karen Reed, whether on her own initiative or, as the defendant posits, the influence of other denizens of the online community, such as Catherine Peters. Gattani contacted Lieutenant Brian Tully, who was leading the NDA investigation into intimidation of witnesses in the Reed case by the defendant. Who told her to contact Tully? Anyone? Anyone? Who gave her Tully's contact information? Tully interviewed Gattani. The Commonwealth had already developed another witness, Natalie, the German, who could attest to communications between Karen Reed and the defendant during the months of April and June 2023. Gattani's information confirmed such contacts after that date based on what the defendant had told her. Tully reported on the interview to Special Prosecutor Ken Mello, who had Gattani served with a grand jury subpoena, right? The grand jury subpoena was for the 2023 case. Okay? You can't now claim she's not important to your case. She's not a witness. And this is what his argument is going to be. We don't need Lindsey Gattani as a witness because we have Natalie the German. So even though Lindsey may be a witness, we're not going to call her. We don't need her, and therefore no conflict, even though she's suing me and the DA's office. That's not the way it works. Back to the papers. Gattani had apparently hoped not to have to testify and began to panic upon receipt of the subpoena, what I call the bump, the nudge, the setup. They served her with the subpoena because they knew that would be a trigger for AIDAN. They knew she'd want to talk to him about it. They knew that they could then get them in the same place so that they could claim that something happened to put him in jail. And that's exactly what they did. That was the bump. She telephoned the defendant and informed him that she had been subpoenaed and attempted to minimize her role in the matter. After some discussion, the two agreed to meet at Gattani's apartment building, where Kearney demanded to examine Gattani's cell phone and took notes on some of its contents. He urged Gattani to delete various items from her phone, representing that he had checked with his attorney, Timothy Bredel, and that there was no preservation order in effect, that there was no problem in doing so. And they're also going to throw Tim Bredel, or at least Kazi is going to throw Tim Bredel under the bus as well. At one point in the early hours of the morning, Gattani excused herself to use the bathroom and telephoned Special Prosecutor Mello, awakening him. She woke him up. Mello had difficulty understanding what Gattani was saying beyond understanding that she was fearful, but effectively arranged to transfer the call to Tully. A brief exchange of messages followed. Then Gattani returned to the defendant. Further conversation ensued, as did other events. After speaking with Kearney the following day, December 24th, 2023, and learning that she had not reported the incident to the local police, Tully did so. Right. Tully took it upon himself to call the police on Aidan. Maybe Lindsey wasn't going to report it to the police. So to ensure that the police were notified, Tully did. See what's happening here? And I talked about this morning in the Brian Walsh case, whether you hate Brian Walsh or not, whether you think he probably did it and maybe he's guilty because he's sitting in the defendant's chair, no matter how you feel about Aidan Kearney and the things that he says and the things that he does, if you think that citizens of Massachusetts or citizens of any state in the as such United States should be treated like this and set up like this, that's insane. It's insane. Just because they don't like what he's saying. They don't like what he's saying and they want to incarcerate him. And they did. They did for 60 days. He was away from his mother, who was dying of cancer, and he was away from his little children for 60 days because they really, 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 really wanted him in jail. And they did it. Hold on. I've seen reporters in the Karen Reed case knocking on doors trying to ask questions. I don't see them getting charged with anything. After Tully reported it to the police, the defendant's arrest soon followed, resulting in revocation of previously imposed bail. Right, because that's exactly what they wanted to do. Kearney was granted a 209A restraining order. The defense's theory, as discussed in the Commonwealth's memorandum in opposition to Attorney Bederow's affidavit in support of motion and associated submissions, is that Catherine Peter, Lindsey Kearney, Mr. Mello, Detective Lieutenant Tully, and possibly others diabolically plotted to have Mr. Kearney's bail revoked by luring him into intimidating Ms. Kearney after they made her what Mr. Bederow describes as a witness. Taking care to put the term in scare quotes. Subsequently, the defendant went to the Medfield police and alleged that Kearney had wiretapped him. Okay, so they're saying that Aidan went to the Medfield police and alleged that Kearney had wiretapped him by recording a sexy type encounter without his consent using a home security camera. As a result, Kearney was interviewed by the Medfield police. And in the course of that interview, Medfield police were informed of a sexy type encounter on October 14th of 2023, which Kearney had recorded. Per Kearney, he sent her a copy of the recording the following day. The question arose as to whether Kearney on that occasion lacked the capacity to consent and thus was graped by Kearney, but Kearney initially did not want to proceed with charges. The police subsequently met with Mr. Kearney and, among other things, advised him that they had a copy of his video of the October 14th encounter. According to Ms. Kearney, on April 13th, 2024, Kearney publicly announced on YouTube, and here's the episode number 654, that Medfield police were investigating him for grape, calling it a lie. This was the first public mention of the allegation initiated by Kearney himself. Kearney launched an online campaign of vilification against Kearney. She was a fake victim, an unfit mother, a drug user who supposedly fell asleep bagging items at the grocery store. She supposedly confined one child to sleeping in a closet and was described in Kearney's postings as closet baby. Kearney was said to be in jeopardy of being indicted. I wonder where he got all that information from. Who do you think helped him with that? Do you think he's watched all the YouTube presentations? I'm not sure. Kearney was said to be in jeopardy of being indicted. On and on the attacks went, with Kearney's devoted online acolytes gleefully piling on, picking up the cry of fake victim, photographing Kearney at various locations, sending accusatory messages to her children's school, and texting with her with obscenities, accusations, and threats. One among Kearney's enthusiastic collaborators in the campaign of vilification vilification against Gattani was Jason Broyles, who initially appeared online under the pseudonym Haley Walbrecht. Broyles serially posted derogatory material about Gattani, interspersed with exhortations to her to prevent him from continuing to do so by, quote, telling, quote, the truth, i.e., publicly adopting Kearney's versions of events and repudiate her own statements. For the record, I want to point out that it is now in public filings that I was not Haley Walbrecht. But boy, the intimidation and the harassment that I endured during the time that it was posited on this cesspool of Twitter that I was Haley Walbrecht is unimaginable. This is the motion to just, yeah, I don't know. Right, exactly. What does this have to do with anything? Right, he just likes to gossip. Everyone hit the like button. Eventually, Gattani responded to the verbal assaults against her on her social media account, denouncing the defendant as a rapist and describing him with other derogatory terms. On January 8th of 2025, represented by counsel, Kearney filed suit in Worcester Superior Court, alleging slander, libel, and intentional infliction of emotional distress and seeking damages and injunctive relief. After an unsuccessful motion to dismiss, Gattani, pro se, filed an answer and counterclaim on September 8th of 2025. And that is when she sued Cosgrove. In the course of litigating a Dedham District Court case involving an alleged violation of the 209A order granted Gattani against the defendant, Cosgrove he's talking to himself. He's talking about himself in the third person. Wait, I'm sorry. Isn't he the one writing this? Is that a tell? Is that a tell that somebody else wrote it? That's bizarre. Okay, here you go. We watched that trial. It was crazy. That was the trial where Cosgrove said, surprise. He jumped up and he said, surprise. But it says here, Cosgrove had provided as discovery the Medfield police report on the October 14th, 2023 incident to Attorney Bredel. Bredel, or someone acting on his behalf, gave the report to Kearney. Kearney provided it to Broyles. On August 8th, 2024, Broyles posted Gattani Files Part 3, including the unredacted confidential police report of Gattani's sexual assault allegations. In A and C, which I am assuming means answer and counterclaim, in addition to answering Kearney's allegations, Gattani attempted to implead Cosgrove, Tully, and a Medfield police officer. The factual basis of all her allegations against Cosgrove, again, he's talking about himself in the third person. Is he adopting Mello's voice right now? I'm so confused. Cosgrove interviewed Cosgrove. What? The factual basis of all her allegations against Cosgrove is that his turning over the report to the defense violated this section of the general law. See, he didn't write it. As the result of Gattani's filing the answer and counterclaim, Cosgrove filed a motion to withdraw from the 24 case, believing that a conflict existed between defending, should it become necessary, against Gattani's answer and counterclaim and prosecuting an indictment where she was the alleged victim and primary witness. So he filed a motion to withdraw. That motion was allowed without argument and without objection. Right. And then that case was dropped. Maybe Brennan's paralegal wrote it, says Mastad, maybe. The defense now seeks to leverage that withdrawal to force Cosgrove's removal from the present case, in which Gattani is not alleged to be the victim and is not a necessary witness for the Commonwealth. Notice the word necessary. That is the important word in addition to percipient, because I submit to you, it doesn't matter whether they call her or not, whether they need her or not. The fact of the matter remains, they served her with a grand jury subpoena for the 2023 case. You can't use it as a shield and a sword, my friends. You can't use it as a shield and a sword. You can't say, well, we're going to serve her with a grand jury subpoena for the 2023 case because she's definitely a witness, in order to tickle the wire, nudge or bump in order to incarcerate Aidan Kearney, and then turn around and say, but yeah, we didn't really need her as a witness because we got Natalie and others. And so she's not important. So I don't need to. No, that's not the way it works. Am I living in the upside down, inside out Narnia of the land of the lost of Massachusetts? Yes, I am. Yes, I am. And the fact that in good faith he can actually argue this gives me not only pause, but grave concerns for the Massachusetts bar. He says all of the named victims in the present case are either witnesses in the Karen Reed case or relatives of witnesses. Gattani is not a percipient witness with respect to any of the counts in the present case. Okay, good. Then why did you serve her with that grand jury subpoena? You can't have it both ways. You can't say, we served her with a grand jury subpoena because we really needed her to testify in front of the grand jury to indict Aidan Kearney. Or say, well, we only served her with that because, we wanted to set up Aidan Kearney. Which is it? To the extent that she would be of any use to the Commonwealth at all on these counts, it would be to testify based on her conversations with Kearney as to Kearney's relationship with Karen Reed, which goes to his motive for the intimidation of the witnesses. Footnote 1. Gattani would be expected to testify that during her relationship with Kearney, Karen Reed would come up in a lot of conversations, or would come up a lot in conversation. Further, that he told her he communicated with her on a daily basis, and that with much of his reporting on the Reed case, he would have to run everything by her, that she had a lot of control or almost complete control over anything that he posted. He was not allowed to make any sort of comment about her case without first consulting with her and getting her prior approval. And that is citing the grand jury minutes from February 1 of 2024, which was a different grand jury. Wasn't that the grand jury to try to indict Karen and Aidan on witness intimidation charges? And it didn't work. Oh, Lindsey's here and she can't comment. Yeah, girl, I'll do that for you. I'll do that for you because listen, I told you I want to talk to you. Hold on. Let me just do that. But now it's going to be like major troll alert. So I don't even know if I have any mods, but it's hard for me to, it's going to be hard for me to mod. And also, do I have any mods here? Okay. But actually, no, Lindsey, you just have to hit the subscribe button and then you can come on and then it will just do any duration. Because no, I'm not getting into that whole thing. Hold on. Okay. Just hit the subscribe button. All right, there we go. I'm mad about this. I don't care if you like Lindsey and I don't care if you like Aidan. But what's going on here is disgusting. And it's a gross miscarriage of injustice. And it's horrific. Terrific. Women of Massachusetts should unite because this is gross. Oh, look, Cupcake is here. Okay, she might be at work. Where were we? Footnote 1. If the Commonwealth wishes to introduce such information, it can do so through other means, including the contents of 2 of Kearney's cell phones seized pursuant to warrant, which show extensive communications between the defendant and Reed, as well as communications with some of Reed's attorneys. In short, there is no need whatsoever for the Commonwealth to call Gattani and no need for prosecution to, as the defense points, defend the credibility of a prosecution witness who has sued him for his alleged misconduct. It doesn't work like that. Doesn't work that way. You can't use it as a shield and a sword. My name is going to be next on the witness list? Yeah, I don't think so. What am I a witness to? The defendant argues, however, that it will call Gattani, who has apparently now, for whatever reason, made a complete U-turn and taken a Kearney-like position, that Special Prosecutor Mello and Lieutenant Tully conspired with Kate Peter to use her and sacrifice her as a pawn to take down Kearney, and that therefore Cosgrove should be disqualified on the ostensible grounds that he is somehow ethically conflicted from cross-examining her. Well, we can all see it. We can all see it. That's exactly 100% what happened. Right? Footnote 2, which says, the prosecutor is not required to uniformly buttress or implicitly vouch for the entirety of the testimony of a witness he calls. Dude, really? Are you really going to argue this? The modern view in the law in Massachusetts is that subject to a few limitations, any party, including the party that called the witness, may attack her credibility. Okay, really? Really? She's suing you. She's suing you. And she's suing the entire DA's office. And here she is. Here she is, the one, the only. I've been sticking up for you, Linz. I have been. Ask the chat; they will tell you. And if anybody attacks Lindsey Gattani right now, you're getting kicked out. Like there's a no mercy rule right now. She's here, and she says, "This is wild. I'm still trying to digest it all. The entire response is all Kate Peter tactics. I'm not a necessary witness anymore. Do they forget they interviewed Natalie before me? Right. And not only that, they flew to California to interview Natalie. They flew there on the Commonwealth's dime. But now they're like, oh, well, Cosgrove really wants to keep dipping, triple dipping. And he's already billed. So right now he should just recuse himself. This whole thing is a sham. It is a farce. It is a joke. And also, Lindsey, I have a question. You don't have to answer it right now because I don't want you to say anything that you're not comfortable saying. But we know, because we just read, because Cosgrove said it, that Tully's the one who called the police on Aidan the next day. It wasn't you. It wasn't you. Did they force you into pressing charges against him? And I'm not even going to ask you that, but this is what I'm thinking. Tully's the one who called the police. It was Medfield police, right? Tully's the one who reported this grape. And it's disgusting. And what they did to you was disgusting. And the fact that they didn't redact anything and that they released all this stuff is disgusting. And the fact that they released your entire phone extraction is disgusting. And I've said this throughout. The chat will tell you that has been my position throughout. And this does not happen. I've never seen this happen before. And we know you keep receipts. And we know that you, Lindsey, are way smarter than any of them. That's for sure. Way smarter. Because you kept receipts when you figured out they were using you. Should this court... Oh, wait, where do we go here? Whatever purchase this argument may have for the now dismissed complaints where Gattani was herself the alleged victim, there is no basis for dragging the entirety of that dispute into the present indictment, where Gattani accounts for virtually zero of the Commonwealth's evidence, either in its collection or its presentation. Okay, you can't have it both ways. Then why did you subpoena her to testify for the grand jury for the 2023 case? You can't have it both ways. Lindsey's going to be the surprise hero in all of this. She is. She's going to be the one that cracks wide open the case into the murder of Boston police officer John O'Keefe. I just know it. I just know it. I love a plot twist too. You can't, there's no backseas, okay? There's just no backseas on this, Cosgrove. You can't just be like, oh, here's the subpoena for the 2023 case. Oh, but we didn't really mean it. We take it back. Lindsey's the smartest of them all. She's like a fox. She's smart as, like, it's, they tried to use Lindsey as a short and a seal. and a sword, a sword and a shield. You're right. You're right. And you know what? When nobody else stuck up for her, she stuck up for herself. Oh, she responded about Tully. Hang on, I gotta scroll back. Because you know, there's 8,187 people in the chat, so the chat's flying. Hold on. Hold on. Yeah, they think the little people can't take him down. That is right. Crystal. Lindsey says, yes, it was Tully. And it wasn't because he realized I hadn't reported it. It was because I didn't want to report it. I was crying, begging them not to call because I knew it would make things worse. Yep. Old Big Dog says they 1,000% used and then abandoned Lindsey, a single mother of 3. It makes my blood boil. Yep. That's what they do. They don't realize that LawTube is 90% women. We don't do misogyny. There's a special place in hell for women who don't support other women. Unless, of course, you know, they do something personally to you. Lindsey has 4 kids, okay? But the comment that I read from Big Old Dog said 3 kids. I thought it was 4 kids also. Lindsey didn't want to report it. They used her. They used her because maybe the House defendants, in my opinion, wanted Aidan in jail. And aren't there also some text messages that have surfaced about, or some, I don't know. Isn't there some evidence that perhaps some people would not testify unless Aidan was in jail? Maybe. Is there some evidence of that? Isn't that intimidation by Tully? Says Melissa. Yeah. Isn't it? And Lindsey, I said this when you filed your counterclaim too. I said it. I said, I think Lindsey's got a really good case. Didn't I say that? I think I remember saying that. Right. Zeta says it took a lot of courage for Lindsey to stand up for herself. Unfortunate taste in men is not a crime. All right. If you're really sorry, you'll testify at the grand jury. Isn't that what they told you, Lindsey? If you're really sorry, you'll testify at the grand jury. Somebody said, and I think you did say that. I think that is part of your story. Courtney says, I can't wait for Lindsey to jump up in court and yell surprise. I'm glad she's telling us everything. Lindsey's also the one coming up with all the missing evidence that they said they didn't have. You know, Leah Beth of Genduso's voice memo about, oh, Lindsey, I just thought of something. If you call Tully and you say you're a witness, then, I mean, it's been a long time since I worked for MSP because, you know, I got fired and stuff for, I don't know, drug dealing or something like that. But I seem to recall, like, if you are a witness, then he can't come after you and he can't blog about you. And that would be so great. Well, you should call him. This is all part of the story. That's part of the setup. Knowing someone's triggers, befriending them. And then the second you don't need them anymore, just like he's telling us here, he's telling the whole world this in his publicly filed papers. Yeah, we don't need her anymore. We don't need him anymore. We don't need her anymore. We don't need her. We got Natalie. We don't need her. But he'll argue it just to Bill. Bill. I don't know where I left off. Whoever, whatever. And then says, A side trip into whether the Commonwealth did or did not properly conduct the Gattani investigation is irrelevant, not probative, and highly prejudicial, threatening to turn the trial into a circus. Oh no, the circus is here. The circus is coming to town. And if you want to continue to be the ringleader, Cosgrove, by all means, we'll get you a hat. We'll get you a top hat. Maybe even a baton. But the circus is here and the circus is in town, and we're not shutting up about this. How many civil rights have been violated here? Steve-O wants to know. All of them. All of them. Be a truth, live factually, says Be Strong Lindsey. Everyone deserves not to be used and abused by men with power. The Commonwealth will vigorously oppose the attempt to divert the jury down this lengthy and winding side road to nowhere but confusion. This entire case is a side road to nowhere but confusion. We're in the land of confusion. It's part of the playlist. Should this court, after hearing, permit the proposed Gattani defense testimony to the extent that Ms. Gattani's U-turn contradicts previous statements made under oath, she may expose herself to legal peril. Oh, are you threatening her now? She may expose herself to legal peril, and the court should ensure that before she proceeds, she has appointed counsel. Clearly, her interests are far from synonymous with Mr. Kearney's. That sounds like witness intimidation to me, in writing by Cosgrove. Hold on. I'm going to read this again. Listen up, buttercups. Top of the paragraph. Should this court, after a hearing, permit the proposed Gattani defense testimony, as in, if we have a hearing, judge, and you decide that Lindsey Gattani should be able to testify for the defense, to the extent that Ms. Gattani's U-turn contradicts previous statements made under oath, she may expose herself to legal peril. And the court should ensure that before she proceeds, she has appointed counsel. Wow. Are you saying that you would, well, you can't because you're just a specially appointed prosecutor. Are you saying that the DA would actually file perjury charges? File perjury charges against someone? Really? Is that a threat? And it says clearly her interests are far from synonymous with Mr. Kearney's. Okay, but it's okay that Kerry Roberts lied to the grand jury, and that was brought out in open court. So Cosgrove, you want to open that gate? Let's go. Floodgates are open. How dare you? How dare you threaten her in publicly filed court papers? Does Lindsey have an attorney? Everything she's filed pro se, first of all, is been pro se and very well written. So I don't know if anybody's helping her write it, but I also know from reading things that she has written that she seems to be very smart. And I'm sure that there is a lawyer out there who is admitted in Massachusetts that would likely represent you. Because what I'm reading in this paragraph is outrageous. And it should never, ever be in any public court filing. How dare they? Larry says that's grounds for disqualification on its very own merit, on its very own. Be in trouble says the corruption doesn't stop. Summer Coffee and Trials says it's a scare tactic on Kazi's part. Yes, but the threat of charges is unethical. To threaten someone with litigation or criminal charges as an attorney is unethical. Are there any other lawyers in the chat? I'm sorry. Did I know it was a very, very long time ago that I took the bar and the MPRE, but I seem to remember that the threat of legal action is unethical. And that's a threat. Did Cosgrove even read this before he filed it? Because this could be problem for him ethically. Hold on a second. One second. Rosemary Scapicchio, maybe. Oh, Tom Kokonowski, maybe. I don't know. If Lindsey had a legal defense fund, would anybody donate to it? Would an attorney take it on contingency if it's a strong civil rights case? Probably. Every civil rights case I ever took was on contingency because I'm a civil litigator. That's what I do. Wow. Threatening her with perjury. That's rich. That's rich. Who else committed perjury in the Karen Reed trial that we can prove? I mean, Carrie Roberts admitted to it on the stand. So, I mean, she's got an under oath admission of lying to the grand jury. She admitted her perjury on the stand. I'm not trying to solicit donations at all. But what I'm saying is the House defendants are soliciting donations for what? To pay for their lawyers so that they can sue Karen Reed and AIDAN for defamation? I still don't know. Kelly Dever, did she commit perjury? Can that be proven? Maybe. So by all means, Cosgrove, if you want to start suggesting that people should be persecuted for perjury in Norfolk County, by all means, do it. He didn't write this, and I don't even think he read it. And then he says, clearly, her interests are far from synonymous with Mr. Kearney's. Finally, the Commonwealth notes, to the extent that any disability arises from Ms. Gattani's answer and counterclaim, whenever, if at all, the counterclaim against Cosgrove goes before the Middlesex court, it is unlikely to survive a motion to dismiss or for judgment on the pleadings. So he's like, okay, so even if you know her complaint succeeds, it's going to get dismissed and she doesn't have a valid claim, and therefore it doesn't really matter. No, that's not how that's not how it works either. Its entire basis is an act by a prosecutor in the course of his duties, and whether or not Cosgrove was correcting, and again, whether or not Cosgrove was correct. This is supposed to be written in the voice of Cosgrove. Who wrote this? Who signed it? Cosgrove signed it. Okay? Today. Its entire basis is an act by a prosecutor in the course of his duties, and whether or not Cosgrove was correct in concluding that providing a copy of the police report to the defense was proper, Rule 14 discovery, no liability should attach. Okay, it still doesn't excuse you from the conflict. Because you don't think her lawsuit's going to be successful doesn't mean that you don't have a conflict. The defendant's third and final request is perhaps his most brazen. He asks this court to disqualify Cosgrove from an ongoing investigation of Karen Reed and Mr. Kearney for conspiracy to commit witness intimidation. The 2005 investigation. Are we going back in time now to 2005? Again, based on the alleged irreconcilable conflict. I always think of irreconcilable differences, and so I have to train myself to now say irreconcilable conflict with Ms. Gattani. To facilitate his demand that this court preemptively intrude on the lawful authority of the executive branch, Kearney attempts to mount an attack on a search warrant authorizing seizure of cell phones belonging to Karen Reed. And then they talk about a taint team and then search warrants. But then he says, presently, the matter of Karen Reed search warrants and the establishment of a taint team is before the court. Judge Krupp, having heard argument, received memoranda and taken the matter under advisement. So we know from the conference we just listened to, the Zoom conference, that Krupp has taken this under advisement, and we don't. When did they say when he's expected to render a decision on whether he's going to allow the the super late Jen lied to the FBI? That's right. That's right. Did they say when he was expected to render that decision? No. Hmm. Hold on a second. Oh, please. Like Bethany Frankel said, a hate watch is still a watch, right? Still counts. A hate sub is still a sub. New judge said soon. Okay. He keeps calling himself in the third person because he clearly didn't write this. He clearly didn't write it. I don't think Aidan's case is ever going to get to trial. They can talk about a trial in 2026, but I don't think it's going to happen because Cosgrove has to be disqualified. Marcy's office has to be disqualified. And who else is going to persecute him? You think another DA from another county is going to want to get into this mess? I don't think so. I've been wrong before, but I don't think so. And then it says here that Karen Reed would be the only one to have standing to make a motion to have him disqualified on that issue. Oops. He says, or whoever wrote this says, it is part of the normal search warrant process. Assuming the court allows the Commonwealth's motion to set up a tainting procedure with regards to Karen Reed's phones we're talking about, and assuming search warrant number 2 is authorized by the court, and assuming a resultant search yields evidence, and assuming that evidence results in a grand jury presentation, and assuming that grand jury then indicts Karen Reed, then Karen Reed, as in any other case, may bring a motion to suppress that evidence. Karen Reed may bring such a motion, not Kearney, who has no standing, as he lacks any possessory or other cognizable legal interest in Karen Reed's phone. Yeah, but what's interesting is that they filed it for some reason under Aidan's case number, right? That's the thing. Oops. Why did they do that? Why didn't they file it under Karen Reed's case number? Cosgrove is the one who filed it. All of a sudden, he's now the specially appointed prosecutor also for Karen Reed. And then he submits an affidavit at the end. And he filed this just today. What say you? All right, we're going back to today. We're going back to, we're going back to a 3-day subscriber level. Lindsey, even if you wanted to, I wouldn't bring you on the show today because I want to talk to you off camera. I don't ever want to put you in a position to make you say anything that you don't want to say or talk about anything you don't want to talk about. But if you want to contact me, my email is in the show notes below. Please do. But there's a lot of people that I thought were like, I don't know. That's it. That's all I'm going to say. All right, moving on. We also have Bederow's reply, but let's go to the questions first. Nobody would believe this if it's a movie script. Nobody would believe it. Cindy says, what judges recused in Aidan's cases? I don't know. Did any judge recuse himself in Aidan's case? I don't know. Did I say that, or did someone in the chat say that? If somebody can tag Cindy from Virginia, let her know. Leslie, thanks for becoming a member. Gen X Jen says, today it's Turtleboy, tomorrow it could be you. Ms. Holmes says, seems to me that Kazi can't do his work because he's up late at night watching Aidan, Kate, Peter, and LG on X. Kazi, go to bed, wake up, recuse, and dismiss this BS. Thank you, Lumen, for becoming a member. Kyle says, Lindsey is going to wish she never betrayed Turtleboy. Thank you, Steve, for becoming a member. Clamasu says, window dancing is not a crime. Thanks for your 5. Real beer bower says, do it, Lindsey. Thank you also for your super chat. And really, I see you gifted 10 memberships, and that's because you guys are awesome. And hey to the bakers. Hey, bakers. Welcome. Welcome. All right, moving on. We also have do you want to hear the reply of Mark Bederow that was filed either yesterday or today? Linda, thank you very much for your $100 Venmo. You're super sweet. Says, well, she's a retired Chicago police commander. And says, thanks for all of your fabulous coverage of the important cases. Right. Thank you for your service. And nobody hates a bad cop more than a good cop, right? Thank you, Linda. You're amazing. Nancy, thank you for your Venmo. Just says, thank you, Melanie. Thank you for watching and for paying attention and for being interested. And thanks, Heather. So grateful for you and your coverage. You're the greatest. And moving on. Of course, you guys want to hear it. Of course you do, right? All right, let's hear it. Where did I put it? There it is. And it has hyperlinks. I know, I could tell that too. I could tell that Mark Bederow really had some more things to say. But the judge kept calling on Tim Bradel, who was in his car. And so he didn't get to say, I think, everything that he wanted to say. Here's Truckers Against Tie Clips. He's trucking. Keep on trucking, he says. Thanks for being here for 16 months. You're awesome. All right, moving on. Yeah, I have no interest in practicing law in Massachusetts. I'm retired. It's Massachusetts. I feel like I did my penance against the Catholic Church. That was like a 16-year fight. And I am happily talking to you on YouTube right now. All right, here we go. This is the reply memorandum of law. And this was filed yesterday by our friend, Mr. Bederow. I think we can shut off. Hold on this. Let's go back here. Save. Okay. Chat away. Chat away. It says chat away. And this is signed by Mark Bederow and Tim Bradel. Introduction. The Commonwealth's untimely response is more noteworthy for what it fails to include rather than for what it does. Footnote 1 and 2, which read, in succession, number 1, the defense motion to dismiss was filed on September 20. I'm sorry, all these dates are 2025. The defense motion to dismiss was filed on September 17th. The motion to disqualify Cosgrove was filed on October 3rd. The prosecution was first directed to file its response by October 27th. On October 24th, which was a Friday at 4:58 p.m., after the clerk's office was closed, the Commonwealth emailed the defense a copy of a motion seeking an extension. Unknown to the defense, the court had already granted the motion and directed the Commonwealth to file its response by November 17th. The Commonwealth ignored this deadline and served the defense on Tuesday, November 25th at 10:55 p.m., which essentially was the day before Thanksgiving. The response was accompanied by a motion seeking an extension, which was tantamount to the Commonwealth seeking forgiveness rather than permission. Who's been screaming that at you? Me. Footnote 2 says the purpose of this reply memorandum is to clarify big picture issues for the court in advance of oral argument. Strikingly, Mr. Cosgrove ignored the elephant in the room. He and lead investigator, Detective Lieutenant Brian Tully, have been sued by witness Lindsey Gattani for intentionally harming her during their prosecution of AIDAN Kearney. And that hyperlink goes to Lindsey Gattani's defendant's answer and counterclaim that was referenced in the Cosgrove alleged reply that we just read. And it is, and we've been over it before. Lindsey's answer and counterclaim is 91 pages long, and it was filed on September 5th of 2025. And it has lots and lots of exhibits, and we looked at them in detail on another stream in full. Tully and Cosgrove have been sued by witness Lindsey Gattani for intentionally harming her during their prosecution of AIDAN Kearney. Without more, the court should refuse to consider Mr. Cosgrove's submission unless the court concludes that he shouldn't be disqualified due to his conflict of interest. The defense detailed how former Special Prosecutor Ken Mello impaired the integrity of the grand jury proceeding. One expects that the Commonwealth would oppose serious allegations of pervasive prosecutorial misconduct by including with its response a detailed sworn statement from Mr. Mello. Yet, rather than submit any sworn explanation from him, the Commonwealth provided woefully inadequate, unsworn hearsay from Mr. Cosgrove designed to justify Mr. Mello's misconduct. Yes, they did. And it was in the voice of Mello. It was wild. Acutely aware that Mr. Mello's too many to count errors before the grand jury impaired its integrity, the Commonwealth mostly ignored addressing his misconduct or case law supporting the defense. Instead, it urges the court to avert its eyes from the flawed grand jury proceeding by concluding that the defense waived this argument. As detailed below, the Commonwealth's preference for form over substance sought to mislead the court by ignoring binding precedent contrary to its position and by relying upon inapplicable civil practice rules, right? Because, it's a criminal case, folks. It's a criminal case. Argument point 1. The court should not consider the Commonwealth's response unless it determines that Mr. Cosgrove should not be disqualified. That's exactly what I was saying. This is a cold read for me because I, unfortunately, was so busy last night and today that I didn't get a chance to read this yet. The irony of Mr. Cosgrove's snarky criticism of the defense motions should not be lost on the court, given his failure to address the blatant conflict resulting from his prosecution of a matter in which Ms. Gattani is both his accuser and a witness, and where her credibility will conflict with that of his co-defendant, D.L. Tully. Footnote 3. On October 8th, 2025, in a related hearing regarding his ongoing effort to search Karen Read's cell phones, Mr. Cosgrove acknowledged the problem of whether it was appropriate for him to respond to the disqualification motion, Exhibit A. If Mr. Cosgrove realized that it was improper for him to respond to that motion, he must also recognize the problem that exists. He must also recognize the same problem exists with the Commonwealth's response to the motion to dismiss. Oh, and here we have a transcript a transcript of those proceedings. It is quite long, but I'm going to submit to you that it says exactly what Mr. Bederow says that it says, which is that Mr. Cosgrove acknowledged the problem of whether he could respond to it. And that too was a disqualification disqualification motion. But leave it to Olivia to hyperlink the transcript to that hearing for the court's convenience. Although Mr. Cosgrove avoided directly confronting his conflict, he unwittingly illustrated why he must be disqualified. He believes that Ms. Gattani is a witness who possesses information that is favorable to the case he is prosecuting against Mr. Kearney. As Mr. Cosgrove wrote, quote, discovery provided by the Commonwealth shows that Gattani was indeed a witness. Interviewed by the police with specific attention to what she knew about Kearney's ongoing communication with Karen Reed. After that interview, she received a summons to testify before the grand jury, and that is included in the Commonwealth's memorandum at page 16, a previous memorandum. Understand also that the Cosgrove's response that I read to you right before this, these two things crossed in the mail. Okay. So when Mr. Bederow wrote this, he did not have Cosgrove's response to the motion to disqualify. And when Cosgrove or whoever wrote that for him wrote his opposition to the motion to disqualify, he did not have this pleading. Okay. Dig? Okay. It is hard to fathom a conflict worse than one where a prosecutor / civil defendant concedes that a witness / plaintiff suing him possesses information helpful to the prosecution. It is worse. Ms. Gattani wasn't simply interviewed by the police. She was an important witness against Mr. Kearney, who was debriefed about the subject matter of the instant indictment by D.L. Tully. Of course, we need to open this hyperlink. And this is a police report taken by Brian Tully, dated December 18th of 2023. It is a report of an interview of Lindsey Gattani, drafted by Tully. And the interview is from December 18th of 2023. And it's long. And maybe we'll have a chance to look at it later. I don't know that I have time to go over all the hyperlinks today because I've been talking to you guys since 8:45 a.m. and I'm getting wicked tired. That might have to be a separate show. It is worse. Ms. Gattani wasn't simply interviewed by the police. She was an important witness against Mr. Kearney, who was debriefed about the subject matter of the instant indictments by Tully, who just happens to be Mr. Cosgrove's co-defendant in Ms. Gattani's lawsuit. Lest there be any doubt that Ms. Gattani was an important prosecution witness, Tully relied heavily on her information to establish probable cause to obtain a warrant to seize Ms. Reed's cell phones, which years later, Mr. Cosgrove seeks to search. And that is what I presume is Tully's probable cause affidavit to search and seize Karen Reed's cell phones. And it is very long. That absolutely needs to be done in a separate show, separate hyperlink show. Mr. Mello instructed Tully to serve Ms. Gattani with a grand jury summons, the purpose and timing of which has led the defense to argue that the investigation of Mr. Kearney was conducted in bad faith. In his overly sarcastic eagerness to ridicule this theory, Mr. Cosgrove unintentionally confirmed his conflict by emphatically agreeing that Ms. Gattani is a relevant witness in regard to the matter, or this matter. And then he's saying, please see the transcript of the hearing that is also attached and hyperlinked here too. Mr. Cosgrove similarly ignored the significance of his accuser's allegations against his co-defendant. While flippantly mocking the defense conspiracy argument, Mr. Cosgrove highlighted the intertwined conflicts arising from Ms. Gattani's and D.L. Tully's dispute regarding whether any content was deleted from her phone before an extraction report was provided to the defense. Ms. Gattani has repeatedly accused D.L. Tully of deleting evidence from her phone. D.L. Tully denies this. Mr. Cosgrove has effectively accused Ms. Gattani of lying by supporting D.L. Tully's claim that any missing data on the extraction report was removed from Ms. Gattani's phone before he took custody of it. Oops. It seems to me to be a question of fact for a jury, or an evidentiary hearing. The conflict is further exacerbated by Mr. Cosgrove's support for Tully's position about his communicating with Ms. Gattani and the contents of her phone, citing a May 8th, 2024 letter, and his assertion that cell phone expert Tully couldn't access his text communications with Ms. Gattani from his iPhone, citing a June 8th, 2024 letter. All of these examples establish that Mr. Cosgrove's conflict is suffocating. In addition to endorsing Tully, endorsing is in quotes, and effectively discrediting Ms. Gattani, he has made himself a witness in the inevitable sworn dispute from the witness stand between Tully and Gattani over the contents of her cell phone. While it is admirable that Mr. Cosgrove desires to prosecute this contentious matter, he cannot close his eyes and wish away an obvious conflict where the interests of a witness who should be favorable to the Commonwealth are directly adverse to his personal interests as well as those of the lead detective. For these reasons, and those described in prior defense submissions, Mr. Cosgrove must be disqualified from this case, and the court should reject the Commonwealth's November 25th, 2025 filing. Footnote 4. Which says, on September 22nd, 2025, Mr. Cosgrove moved to withdraw from now dismissed docket number 2024, that was the Lindsey case, because of his conflict with Ms. Gattani. He reasoned that he was ethically precluded from prosecuting matters where Lindsey Gattani is an alleged victim of party. Any perception that Mr. Cosgrove's conflict was created solely because Ms. Gattani was an alleged victim or party, as opposed to merely a witness, is a distinction without a difference. Right. You can't just say, and this is not Bederow's response to what we just read, by the way. He's still going to respond to that one. It's Chinatown. Forget it, Jake. It's Chinatown. Point 2, the defense has not waived its right to argue that the Commonwealth impaired the integrity of the grand jury proceeding. To the extent that the court entertains the Commonwealth's response before addressing Mr. Cosgrove's conflict, it should summarily reject the Commonwealth's crafty argument that the defense has waived its right to argue for dismissal on the basis that the integrity of the grand jury proceeding was impaired. According to the Commonwealth, the defense has not satisfied all of the prerequisites of Superior Court Rule 9D before seeking dismissal of the indictments after a prior dismissal motion was granted in part and denied in part. The Commonwealth's emphasis that the defense has flouted all of the prerequisites implies that Rule 9D is binding on the court. This is profoundly misleading. The rule applies to civil cases. See Superior Court Rule 9, styled applicable to all cases. All civil motions shall be governed where applicable by Court Rules 9A through 9E. In any event, it is well established that the court may consider the pending defense application, even if it concludes that the pending motion includes grounds which could have been raised in a prior filing. Citing some case law. A court's power to reconsider a prior decision during the pendency of the case is firmly rooted in the common law irrespective of Rule 13 of the Massachusetts Rule of Criminal Procedure, citing some other cases which are also hyperlinked for the court's convenience. If the court does accept the Commonwealth's response, the prosecution, of course, may advance any good faith waiver argument, footnote 5, which says the Commonwealth ignores the fact that the defense has also moved for dismissal of the indictments on the basis that the prosecution has engaged in egregious, deliberate, and intentional misconduct, the cumulative impact of which includes misconduct before the grand jury. See the defense memorandum of law. So they didn't even address that in their opposition. But the Commonwealth is not entitled to mislead the court on the applicable law, citing one of the rules of professional conduct. Point 3. The court should reject the portion of the Cosgrove affidavit containing hearsay from Mr. Mello. Mr. Mello was assigned to this matter for more than 2 years, despite the defense frequently raising the issue of Mr. Mello's conflicts on 2 matters. He has been disqualified from the 2024 indictments. The Commonwealth only consented to Mr. Mello's disqualification from the instant matter on November 25th of 2025. So he was disqualified from one, and then they null pros the other. Okay, now I'm remembering it properly. Mr. Mello is entitled to sympathy due to personal challenges he has faced for more than 1 year. Oh, no, wait, I'm thinking about Cosgrove. This is Mello. Mello was disqualified from the 2024 indictments. And that was a court order. And the Commonwealth consented to him being disqualified from this case on November 25th of 2025. Mr. Mello is entitled to sympathy due to his personal challenges he has faced for more than 1 year. However, during that period, he has A, attended virtual court proceedings, B, communicated at length with Mr. Cosgrove, and C, has been active on social media. Oh, really? Respectfully, that's where I want a hyperlink. I want to see what he's been doing on social media. Respectfully, Mr. Mello is communicative and capable of using a computer. Nevertheless, we are to believe that Mr. Mello is not electronically sophisticated, according to the Tully affidavit, which we read recently, to the extent that he cannot format a Word document. Mr. Mello's formatting problem apparently thwarted him through no fault of his own, in quotes, from returning an affidavit Mr. Cosgrove prepared and emailed to him. Mr. Mello's formatting conundrum serves as the Commonwealth's proffered excuse for failing to submit a sworn statement from him in response to detailed allegations of his pervasive misconduct. Thus, the Commonwealth apparently had no choice other than to file hearsay from Mr. Mello in Mr. Cosgrove's affidavit, which amounts to nothing more than Mr. Cosgrove cosplaying as Mr. Mello in different font and typeface. I did point that out. All of this is absurd. He's being so much kinder than I was about it. Mr. Cosgrove was a prosecutor for 20 years, after which he served as a Superior Court Justice for 14 years. Mr. Cosgrove's impressive credentials led Norfolk District Attorney Michael Marcy to personally ask him to help Mr. Mello with legal analysis and motion work. And yes, that was in Cosgrove's affidavit. Mr. Cosgrove has extensive governmental resources available to him, including the authority to utilize police officers as he sees fit. In these circumstances, it strains credulity. We've got merch. That an experienced prosecutor was unable to secure a sworn statement from Mr. Mello on critical issues that only he could answer. Mr. Cosgrove could have prepared an affidavit for Mr. Mello, inserted the revisions suggested by Mr. Mello, and had someone bring the document to Mr. Mello for him to review and sign. Mr. Cosgrove could have had an employee from the DA's office help Mr. Mello format his Word document. Instead, I lost my place. Instead, Mr. Cosgrove apparently waited as Mr. Mello struggled to format a Word document before he simply gave up and himself swore what Mr. Mello purportedly told him. Yes, thank you for Alice. How about some Twilight Zone emojis in the chat? Because it is the Twilight Zone, and sometimes it is Land of the Lost. And we have Chaka up there as our mascot, because that's where we are right now. We are. Virtually all of the alleged misconduct cited by the defense was attributed to Mr. Mello. Mr. Cosgrove's decision to engage in lengthy one-on-one conversations with Mr. Mello before he adopted his voice and swore to what Mr. Mello told him, conveniently shielding Mr. Mello from being placed under oath while still affording the Commonwealth to explain his actions through Mr. Cosgrove without legal consequences. Without legal consequence, period. You too can adopt Ken Mello for $1 a day. Do I hear $2 a day? Do I hear $3 a day? It might cost more to feed Mr. Mello than $3 a day, but you too can do so. Apparently. This is inappropriate. Well, I could think of a lot of other adjectives for inappropriate, but I'm going to let Bederow use his Bederow judgment on this. The court should reject all statements attributed to Mr. Mello in Mr. Cosgrove's affidavit. I mean, clearly, duh. But, the fact that he even submitted it like that, Cosgrove, is laughable. Moreover, the bizarre manner in which this is Freaky Friday. I feel like we're in Freaky Friday. I might go back and retitle the stream. Moreover, the bizarre manner in which Mr. Mello's statement has been presented makes Mr. Cosgrove a witness at any hearing on the defense motions regarding numerous issues, including conversations between Messrs. Cosgrove and Mello about the latter's proposed revisions and his inability to execute an affidavit. He just made himself a witness Again, he made himself a witness. So if you didn't like all the other arguments about why he should be disqualified, maybe this one will stick. New Judge Belizos. I'm rarely on the fence about anything at all, because the only thing I get from sitting on a fence is like splinters, and I don't like splinters. But I'm on the fence right now about Judge Belizos. But from all the reviews that I've heard from attorneys who practice in Massachusetts, they think that he's a good guy. I don't know. Don't hold the fact that he grew up in Canton against him and may know some of the people. Freaky Friday and running on fumes, literally. That's how I feel. And Strange Credulity is here. And she says, surprise! I've entered the chat. Thank you. You can't make this up. You can't. Such a scenario will create another problem for the Commonwealth, since Mr. Cosgrove is the last man standing on the Kearney prosecution team. They need to evict the evidence from Mello's house, says Ms. Jessica. Accordingly, the court should strike paragraphs 26 to 58 from the Cosgrove affidavit. How much do you want to bet Cosgrove is going to run to the courthouse today? Because he got the idea from Mr. Bederow to send somebody to Mello's house or bubble or wherever he is, like the boy in the bubble from Seinfeld. I'm picturing the boy in the bubble from Seinfeld right now. If you get that reference, then you understand me. Conclusion. For the foregoing reasons and those stated in the prior defense submissions, the court should determine the defense motion to disqualify Robert Cosgrove before considering the Commonwealth's memorandum in opposition and grant the previously requested relief. Bubble Boy. It was Bubble Boy, right? December 4th, 2025. New York, New York. It's up to you. New York, New York. Start spreading the news. Mr. Bederow. Signed by Mr. Bederow and Mr. Bradle, who both need a vacation more than anyone I know. Praise be, under her eye. We're living in a real life Handmaid's Tale. And you just read, I guess maybe Cosgrove's cosplay affidavit, or the one that we just read in the third person, might be like a real life episode of the Handmaid's Tale that we are living in, right? I don't even know. I have to digest this. I don't even know. I don't even know. I can't even explain this to you because I've given so many TED Talks today that I've lost count, but oh yeah, well, not John Travolta's Bubble Boy. That was a different movie. It is Bubble Boy, the Seinfeld reference. Zoe said earlier, what's that now? 3 months for a tame team for Turtleboy cell phones? Who's paying that bill for the slow moving tame team? Really? I see you gifted 10 memberships. I think that I thanked you earlier, but thank you again because you're awesome. Gilmore Girlie became a new member. I love that show so much. Gilmore Girls. Oh, or Gilmore. I love that show so much. Gilmore Girl. The Goodmans are here and they gifted 5 memberships because they're awesome too. Thank you. You're amazing. And Krista says, in case you need to hear it, you're amazing. Oh, thank you. Thank you so much. You know what? Since this is a new stream, can we pull another affirmation for a badass? Because we already pulled one for today from the other stream. We need another one. Thank you for being here for 4 months. And if you guys haven't watched it, go watch Bethany Frankel's interview with Call Her Daddy. It's really good. And they said some great things about hate watching and hate watchers. And a view is a view. If you don't have haters, then, you know, if you have haters, you're doing something right. Something like that. Okay, here we go. Another affirmation for a badass for today. It's okay. Mistakes are just proof that you're trying. Don't give up. Maybe this one's for Lindsey. I don't know. I got it. There it is. It's okay. Mistakes are just proof that you're trying. Don't give up. Only in Massachusetts. Massachusetts. Stephanie Anthony says, thanks for the membership. It wasn't me. Whoever gifted it to you. Thank you for gifting Stephanie a membership. And thanks for your super chat, Stephanie. Dr. Russell's Gasp is here. And she says, Melanie, you're the best. Thanks for everything you do for us. Thank you for being here, for listening to my rants. Thank you for your 5. Gigi says, I hope I didn't upset you with the puzzle comment. I certainly have respect for you. Have a great weekend. What are you talking about? What puzzle comment? Girl, I don't even remember back that far. Was it during this stream or a different stream? I love you. You absolutely did not upset me. Girl, it takes a lot more than some comment that I don't even remember to upset me. I just think whatever it was, Gigi, honestly, I have no idea. I do not even remember that far back in the stream. But no, you did not upset me. The plot sickens, said Elf. Thank you. Thank you on top for your super sticker. Real Beer Bauer says, fundraiser for Lindsey. Please, Melanie. Well, it's nothing that I would do. But I was just, wondering, I mean, if people are going to donate to house defendants, maybe, I don't know. I don't know. Krista, thank you for being a member. Tilly, thanks for becoming a member. And Kyle says, seeing Cosgrove's response, I rescind my last statement. Lindsey was used and tossed by the most corrupt state and DA in the country. Listen, this is why I don't opine on people's personal relationships and what goes on in their bedroom and what goes on in their house and what goes on between people's personal business, because it's not my business. The fact that so many people out on the interwebs think that it's their business what other people are doing and that they have the right to comment and opine on it is wild to me. Like I don't know. Thanks, Kyle. Carrie says, motion to use of Mellow a la Handmaid's Tale. I'll allow it. Off Mellow or off Ken. Off Ken. Off he's just Ken. How about off he's just Ken? When Cosgrove cosplays adopts Mellow's voice. I'll allow it, Carrie. Thank you for your 5. And Krista also gifted 5 memberships because you know what? She's amazing. And Lindsey, again, was here in the chat earlier and said, this is wild. I'm still trying to digest it all. The entire response is all Kate Peters tactics. I'm not a necessary witness anymore. Did they forget they interviewed Natalie before me? I mean, I don't feel like it's my business to comment on other people's relationships. I just don't. Stephanie, thank you for your very generous 50. Says just because it's Friday. It's Freaky Friday, Steph. It's Freaky Friday. Lisa says, great channel, another coverage of the Brian Walsh trial and all the others. Thank you very much, Lisa. Thank you so much. I have some other thoughts that I'm just not really going to talk about right now. Because I'm tired. And I just can't even imagine all of the online hate that I'm going to get tonight from this. But you know what the best thing is? This is something I heard on the Call Her Daddy podcast with Bethany Frankel. They're like, just don't look at it. Just don't go out there. Just don't have it on your phone. Just don't open it. It's very easy. Just don't open it. Just don't look at it. So there's that. Thank you, Krista, for tuning in from Canada. And you guys better hit me with your last thoughts, questions, comments, concerns, because I'm going to sign off. Krista says, thanks for helping us through the most difficult time in my life. Oh, she says, thank you for helping me through the most difficult time in my life. You inspire me and have incredible energy. It is my pleasure to be here for you and each and every one of you, to keep you busy during your work days. And Mitchell, I cannot commit to anything over the weekend right now. Mitchell, could I have a weekend? Could I have a weekend, Mitchell? Mitchell, would that be okay with you? I know. Mitchell, I have been on air every single day, all day long. I cannot promise anything right now. I know you love me. I know you can't stand for 2 days without me, but I cannot commit to a weekend show right now because we're coming back Monday and the Brian Walsh trial is going to go on for at least 2 more full weeks. Okay. If you haven't been watching it, you really should, because it's exciting. It's interesting. It's interesting to see all the same players. Buchanan should be up next week. Proctor is definitely going to be called by the defense, and I'm here for it. And Connor Keefe showed us today that he cherry picked some evidence, and thank you, not a 3 for gift in 5. I'm out, you guys. I'm out. I love you. Tina, thank you so much for your 10. Says long day, get rest. Thank you. For your 20. Thank you so much. Thank you so much. Love you all. Thank you to the moderators. It's been a long day and not so easy, especially when I opened up the chat to let Lindsey in. And then everyone came in to attack her, and it was wild. And this was a good one here. Original Joe Law said, triangulation is at the heart of the mess. If you don't put yourself in the mix with 2, you can avoid a lot of potential messes. Thank you for your leadership. I agree. I'm like, it is what it is. Stay cool, stay kind, stay classy, and stay safe, because it is the jungle out there. Peace. Have an awesome weekend if I don't see you, but you might want to hit your subscribe button and your notification button in case I do see you, because then you won't miss it. All right. I'm out. Love you, mods. You're the greatest. I love you. I love each and every one of you for spending your full day with me. You're the best. Thanks. Peace, guys. I'm out.